Before we begin, I would just like to inform you that this session is being recorded, and if you would like to turn off your camera at this point, we encourage you to do so. We also request that all members of the audience mute themselves if they have not already done so. The symposium is going to focus its discussion on the rights of incarcerated individuals, and we will be asking questions to our panelists relating to Executive Order 21-1, reintegration and collateral consequences of incarceration, solitary confinement and prolonged isolation, and juvenile justice reform. Before we introduce our panelists, we invite the Executive Director of CHRO, Tanya Hughes, to welcome us all at this time.
Thank you, Matri. And good afternoon and welcome to everyone. And thank you to this dynamic 2021 class of interns. I am so excited about today's symposium. While we try to provide transferable skills to all of our interns, we also benefit from each of your contributions. We benefit from all of your renewed, new, and fresh ideas that you bring to our agency on how we can best meet people where they are and how we can best address the needs that we're trying to meet every day as we try to eliminate discrimination in the state of Connecticut as the state's oldest civil rights agency. This is a very large and heavy task that is an undertaking for us, and it includes persons who are incarcerated as well as those who have served their time and are seeking re-entry into society. And so we think it's really wonderful that the 2021 interns have thought it important to focus on the reintegration of these individuals as fully participating citizens. And in order to do this, it may be helpful to approach today's symposium with an open mind that leaves room for the realization that people do change and that it's important to regularly reassess each individual's personal growth and not condemn them to a life sentence for punishment that has been served. So we have a dynamic panel of 6 professionals that will be introduced shortly. And thank you to all who have joined us. Sorry about that. If you have any questions, please do submit them as directed. And thank you again for joining us and enjoy the symposium.
Thank you, Tanya. Now we invite Deputy Director Cheryl Sharp.
Good afternoon, everyone. And I have to say I'm very proud of the executive interns of the CHRO for putting this symposium together. And thank you so much to all of those professionals who are serving on the panel for this discussion. This is a very important discussion that needs to be had today and continued so that we do respect the rights of individuals who are currently incarcerated and those who were incarcerated, and also respect the rights of all of our stakeholders in the state of Connecticut. To that end, when we initially advertised for this symposium today, we used the word, I believe, inmate and roller coaster ride. And I just wanted to address that and say that there was no intent to use language that would be less than sensitive. And so we reissued the flyer to make sure that people understood we were talking about incarcerated persons or individuals who were incarcerated right now or who had been incarcerated. The Commission on Human Rights and Opportunities respects all of our stakeholders, and adding ride to the end of roller coaster was also not intended to mean that there was any joy in serving time or committing a crime or having to serve time for a crime you did, or some people arguably did not commit. And so we just wanted to put that on the record and let everyone understand this is a part of our growth. This is why we need to have these discussions. And welcome to all of you who are going to participate today. Without further ado, I'm going to throw it back to two interns who are moderating this event for us that we are so proud of. This exercise of having a summer symposium every year is designed to grow professionals, and all of the executive interns, you're seeing two now, but all of the executive interns and the interns in the agency did a stellar job this summer in terms of outreach and community engagement. So congratulations to all of you.
Thank you very much, Cheryl. At this time, we like to welcome Representative Robin Porter to give her opening remarks. It appears that Representative Porter is not at the meeting currently. I'm sure she'll join us as we go on, but in the meantime, I'd like to hand it over to Miles.
Hello, everyone. My name is Miles Cabina, and I'm the co-moderator for this event and an executive intern for the CHRO. At this time, I'd like to introduce our panelists. We have Attorney Gail Hardy, who's the executive assistant to the state's attorney, Attorney Anna Maria Puryear, an attorney for the CHRO, Attorney John Capozzi, the juvenile prosecutor in Bridgeport, Attorney Casey Considine, an attorney for the Disability Rights of Connecticut, Ms. Claudine Fox, the Public Policy and Advocacy Director at the ACLU for Connecticut, and Steve Hernandez, the Executive Director for the Women, Children, and Elders Organization. Thank you so much for taking the time to speak with us, and we look forward to your knowledge in the subject. Now we'd like to move on to the question section of our program, so if viewers have any questions for the panelists, please put them in the chat box, and if we have time to answer, we will do so. Thank you so much.
Thank you, Miles. And before we proceed, I'd just like to reiterate the rules for the symposium. We'd like to keep the responses from the panelists within 2 minutes. And for non-panelists, we ask that you please keep your microphones off. For our viewers, please be advised that this session is being recorded. And if you would like to turn your camera off, please go ahead and do so at this moment. With that, let us get started. So, Governor Lamont signed Executive Order SB number 21-1, which details methods that will ensure better treatment of incarcerated people. Within this order, there is a call to reduce the utilization of isolated confinement, both in its longevity and purpose, as well as increasing visitation rates in order to keep incarcerated individuals in contact with their family. The executive order also states that the use of in-cell restraints be reduced to ensure that these individuals are being treated with the highest respect. This question is directed towards Attorney Hardy and Ms. Fox. How impactful do you think the order will be in changing the lives of incarcerated persons? You can just go on ahead.
I'll defer to Attorney Fox first. I know she has a lot of experience in this area.
Thank you, Attorney Hardy. I'm not a lawyer, first of all. I think, so the question is, how impactful is this executive order? To be completely candid, I don't think it's that impactful because we actually had bipartisan support legislation that made it through both chambers that was a little bit more expansive than the executive order that was released after the governor vetoed the PROTECT Act. And so the thing about an executive order is that it is not something that is signed into law. It is a thing that can be withdrawn at any point in time based on this governor or, you know, the next governor, given the outcome of the 2022 gubernatorial race. So to be completely candid, there was a lot of work that went into ensuring the most expansive piece of legislation that addressed solitary confinement and the torture that happens to predominantly Black and Brown people who are incarcerated, because 70% of the people who are incarcerated are Black and Brown, to address the torture that's happening in our society. And our governor decided to veto it and then do something on his own. So.
Thank you, Ms. Fox. Attorney Hardy, would you like to tackle this?
And as I indicated, I know that Ms. Fox and other members of the ACLU had been very active in trying to put forth legislation for the governor. In my capacity, I'm not involved much or actually at all in the legislative process. So, I'll stand on what Ms. Fox responded.
So as a follow-up question for Attorney Hardy and Ms. Fox, how can we ensure that the guidelines set by Executive Order 21-1 are continued in the future?
Turn it into law, overturn the veto. The guidelines of the PROTECT Act and the executive order, what the executive order we're trying to do is address solitary confinement, which means people who are incarcerated right now in Connecticut's prisons and jails can spend up to 23 hours a day in isolation, which again, as the UN has reported over and over again, it is torture. And the PROTECT Act that passed both chambers with bipartisan support aim to reduce the amount of time in cell down to 17 and a half hours. And what we see with this executive order is that instead of decreasing it down to 17 and a half hours, the governor settled on 20 hours or 19 and a half hours or something like that, which is basically negligible from what's happening right now. And so, I think what we need is to see some courage from our elected officials to stand up and say that we don't side on we don't believe in torture. We don't believe that people deserve to be stuck in a box that's this big for 23 hours a day. And what we really need to see is this turn into law rather than an executive order.
Maitre, I want to jump in for 1 second and ask a question for the state's attorney, the ACLU, and any members of the panel. Is there anything that your agency or organization is doing to lessen some of the strife in these particular situations? How are you dealing with this? Because this has been a hot button issue for us. For the state of Connecticut, solitary confinement, and are there alternative measures that are being taken, or what's being done across the state, to your knowledge?
Attorney Sharp, this is Gail. Basically, as far as our legislative agenda is concerned, from the Office of the Chief State's Attorney, we actually have a legislative liaison that participates in drafting the legislative policy of the division. Excuse me. So we don't, as an agency, I know that we didn't put forth any legislation in opposition to or in support of the issue of solitary confinement. I know that it is a very hot button topic and a very important topic to not only the persons who are incarcerated, but also to those family members. And so, as far as, the division's position, again, I don't believe that we took a position. It's probably something that we should be doing as leaders of the criminal justice system.
Thank you. And would any of the other panelists like to add to that? Or are you ready to move on to the next question?
Cheryl, can you hear me okay?
Yes, I can.
Okay,
Welcome.
great. Thank you so much. And if I just may add, it's always important to go back to the why, because I think what we're seeing evidence of in the back and forth about whether or not to use what on the one hand is considered rightly so torture, and on the other hand is considered a tool of law enforcing within an institution. We need to get at that fundamental break in how it is that we consider the role of incarceration in the bigger picture, right? This is less a story, it's as much a story, I should say, about us as human beings and how we treat other human beings. And it's critically important that we remember that. People who are incarcerated do not deserve their human dignity being stripped from them ever. So that's really, for me, the rift that we have to heal here.
Thank you. And Maitrier, sorry to jump in and take over for a second, but right back to you.
Thank you very much, Cheryl. So I guess to continue on with this conversation, how much work remains to be done? Again, this is open to all panelists. What can be done? Because I believe Ms. Fox brought up earlier that in response to the United Nations also has some say in this matter in terms of what is humane. And in response to a letter concerning incarcerated individuals' treatment at the Northern Correctional Institution, the United Nations recently said that repressive measures to which the DOC appears to routinely escort seems to be a state-sanctioned policy, which may well amount to torture. With the closing of Northern Correctional in June, how widespread is the use of solitary confinement, and how much work remains to be done?
So if I may, so the use of solitary confinement isn't unique to Northern Correctional Institution. Pretty much all the prisons have some sort of restrictive housing unit where they place people in confinement where they're confined to their cells for 23 hours a day. So this is not a problem that is unique to Northern Correctional Institution. What was unique about Northern is that it was designed for solitary confinement. It was designed to move incarcerated people from other institutions who may have some disciplinary problems, may have had administrative segregation, which is like segregation based on a certain classification of an individual. For instance, if they are a member of a security risk group or gang affiliated, they would go to Northern for a period of time where they would be in solitary confinement for a significant portion of the day, and then basically have to work their way out of solitary confinement. So DOC continues to use solitary confinement and will continue to use solitary confinement at other institutions. So Claudine Fox said that we need to pass this legislation. We do need to pass this legislation. The PROTECT Act went significantly farther than the executive order even tried to, not just in terms of solitary confinement, but in terms of oversight of the Department of Corrections. There isn't a ton of oversight for DOC. There is a federal law requiring incarcerated people to exhaust their administrative remedies. And as a result, that significantly delays their filing or any oversight by the federal courts. An ombudsman was proposed in the PROTECT Act. It would have provided some oversight and assurance that DOC is following the law or even the executive order. And it's unfortunate that the governor vetoed that, because there were some really good provisions in the PROTECT Act that he didn't even address, such as communications by incarcerated people. The PROTECT Act provided mandatory social visits, limited Department of Corrections depriving people of social visits for punitive purposes. It also required DOC to provide 2 free phone calls per week for up to 60 minutes and prohibits the denial of those for disciplinary purposes. These are tactics that DOC uses that results in people losing communication with family and friends for weeks or months or years at a time. And we need to guarantee, as Stephen Hernandez says, guarantee the humane treatment of people while they are incarcerated.
Thank you so much for that response. So, Attorney Puryear, we wanted to know, how do incarcerated individuals' rights in Connecticut compare to their rights in neighboring states like New York and Massachusetts? And from there, what policies, legislation, or other measures have those states implemented which you think might be helpful for Connecticut to adopt as well?
So I used to work in Massachusetts, so I know a little bit about it. In 2019, Massachusetts had a big criminal reform bill, and they amended some statutes and enacted others that were related to solitary confinement. It didn't go nearly as far as the PROTECT Act had tried to go. Massachusetts Department of Corrections recently came out and said that they will stop using solitary confinement in the next 3 years, but have not provided any sort of clear plan for doing so. That doesn't mean other states haven't done it. Colorado was one of the first states to ban solitary confinement for more than 15 days in 2017. That's the 15-day mark is the mark that the UN has said anything beyond that amounts to torture. New York recently passed a law that was signed by the governor restricting the use of solitary for no more than 15 consecutive days or 20 days total over a 2-month period. In comparison to the Connecticut executive order, Connecticut limits it to 15 consecutive days, but says that you can place someone in a solitary confinement for up to 30 days out of a 60-day period. Punitive segregation is banned in New York entirely for people who are under the age of 22 or over the age of 54, those who are pregnant, and individuals with mental and physical disabilities, among other groups. After the 15-day cap, people would be moved to a high security rehabilitative unit where they would spend at least 7 hours a day outside of their cell for therapy, treatment, and other programs. So this obviously did not go as far as the PROTECT Act. The PROTECT Act was going to limit the use of solitary confinement after 72 consecutive hours, but it does go significantly further than the Connecticut executive order. And I think it's a trajectory that we should be taking as well. I believe a couple of years ago, the governor had implemented, in New York, had implemented some administrative orders that related somewhat to this, and this is what they've come up with a couple of years later. So it's promising that hopefully, we will see that this won't decrease safety and security in these institutions, and people will start to realize that we can treat people humanely without, without decreasing the safety and security of corrections officers or other people incarcerated.
Thank you, Attorney Puryear. Now I'd like to open this question up to all of our panelists.
I would love to add a little bit to this, because while it's really important to talk about not locking people up in a cell for 20 plus hours a day, I think it's also really important to talk about having access to educational classes and programming when people are actually allowed to leave their cells. And outside of the legislative context, I know Washington State has implemented a lot of measures in how it administers its programming for people who are in custody, and they've seen a lot of success with it. When incentives are built into programming, such that when someone attends an educational class or therapeutic programming, they're incentivized by being given additional opportunities, even something like having the opportunity to have lunch in the classroom with their classmates. There was really a positive effect, not only for people who are incarcerated and their opportunities in mental health and well-being, but also no increase at all when you talk about risks, safety and security risks when people are out of cell. And so I think when you're looking at how an entire system is administered, and you're looking at Connecticut, which tends to have a very punishment-based, punitive way of administering its correctional system, such that there's nowhere to go but down. Things continually keep being taken away, and the way I hear people describe it to me is you really have nowhere further down to go. Things just keep getting taken away from you in response to you not doing something, rather than you being provided an opportunity when you do something. And I think that that's really reflective of the way Connecticut's correctional system is operating, and gives a great example of some of the positive effects that can happen when, instead of being based on a punishment-based model, there's an incentive-based model. And so I think that's an important part of the conversation, not just basic human rights, like don't lock people in cages, but really what opportunities and how is the entire system administered to really promote the well-being of everyone, which is going to create a better environment for both the people on the inside and for staff.
Yes. Thank you. Attorney Considine, you brought up mental health of incarcerated individuals. And in the past year, COVID has been something that's impacted the lives of individuals globally. But how has COVID affected the rights and well-being of incarcerated individuals in Connecticut? And based on your understanding, have adequate resources been provided to care for the mental health of incarcerated individuals?
No. There is not adequate anything for provision of adequate mental health care in carceral settings. And I'm sorry to put it so bluntly, but I think what we saw during the pandemic, not just for people who are incarcerated, but also for people living in other congregate settings, was that this out of sight, out of mind approach to putting people away really resulted in them dying. And these populations shouldn't be just forgotten. I think the ACLU of Connecticut can speak quite poignantly to how, especially early on in the pandemic, COVID affected the rights and well-being of people who were incarcerated. I heard a lot from people about how Northern, which as Attorney Puryear mentioned, is by its design meant to isolate everyone who's being incarcerated in there. That was used as a quarantine location. And so when you're talking about someone who's their crime is having tested positive for COVID, and they're being placed into this facility that by its design is intended to isolate them from everyone else, I mean, my goodness, someone is already physically unwell, and you're really talking about placing them in a situation where their mental health and their psychological well-being is now at risk. And I hear a lot that people would love to have therapeutic programming that they could access while in the inside, and there just don't seem to be adequate resources, mental health staff available to provide that. And I think in addition to using Northern as a quarantine, I heard a lot from people that they didn't have opportunities to go outside into the rec area the way that they used to, that they weren't the same opportunities to shower. I mean, some of the very basic things that people do to take care of themselves were just really stripped away in response to COVID. And it obviously had a deleterious effect on the rights and well-being of the people who are in custody.
Thank you, Attorney Considine. Now, I'd like to open the question to all the panelists.
Yeah, Attorney Considine really hit it on the nose, right? Especially around this idea of how Connecticut approaches a punitive punishment-based model for people who we no longer see or view as people, essentially. And that's really what happened with COVID. So a lot of the work that the ACLU was trying to do at the beginning of the pandemic was trying to pull as many levers as we possibly could to ensure to figure out how to save lives, essentially, right? So we approached it from an organizing advocacy model to get the governor to release an executive order around compassionate releases. We tried to work with push the Department of Corrections to figure out a way to do compassionate releases, at least for people who are the pretrial population, people who weren't even serving a sentence yet, but were still locked up in Connecticut's jails in our cities. And when all of those other measures failed, we approached it from the litigation standpoint, where we basically sued DOC in the state of Connecticut for their treatment of people in the prisons and jails around this. And so what we saw was this notion of lack of humanity for people who committed a crime either yesterday or 20 years ago, and who were basically assigned to death boxes. And as Attorney Considine said, the crime that, the punishment that they received for contracting COVID that could have been entirely preventable if the governor cared about it, was then being sent to the most torturous place possible, Northern. And hospitals, prisons aren't hospitals. And that was a message that not just the ACLU, but many advocates and many people that just care about the lives and the dignity of human beings really tried to approach, was that prisons aren't hospitals, and we needed to figure out something better. And instead, we didn't do anything, and people died and families suffered. And so this legislative session, Senator Winfield even tried to introduce a law around compassionate releases. So just in case something like this were to ever happen again, we'd have a lever to be able to fall back on. And even that piece of legislation failed. So what happened during COVID was a failure to people, was a failure to people in prisons, was a failure to families, was a failure to society as a whole. We failed them.
There's an element of history here. You know, we have historically tied personhood to liberty and ownership, and so some of what we're up against is really understanding that personhood should not be tied to either one of those institutions. And once we do that, and seeing the person for who they are, where they are in that particular moment, deprived of liberty because of because they have committed a crime and they are in a correctional institution, we have to remember that the person is existing in this experience and will be out the other side, the full person they were before and during. And it's critically important, to Attorney Considine's point, that we do address all of the resources that that person needs to be successful on the other side of repaying their debt. It's critically important, because otherwise all that we have accomplished is to break the human being within the institution, so that now we are with one voice saying we want you to be a contributing member to society, but with the other actually accomplishing the alternative.
Right. Thank you so much. So we have a question from the chat asking, what do we do with violent offenders who assault staff and other offenders? And anyone who feels free to answer, we really appreciate it. Thank you.
Miles, could you please repeat the question?
Oh, yeah, definitely. So the question is, what do we do with violent offenders who assault staff and other offenders? Like, what do we do in order to assist them? Yeah.
If I may. So I think the thing is what we have to sort of figure out is, where is this assault coming from? You know, is it coming from some sort of untreated mental health issue? Is it coming from, well, what we've seen when we lock people up in solitary confinement for long periods of time is that they will start to act out, and they will hurt themselves and they will hurt others. You know, what's the source of the problem? And I don't think anybody is saying that people shouldn't be held accountable for their actions. And sort of, how do we hold people accountable without, while achieving the ultimate goal, which is to get them to not hurt other people? So, you know, I think the PROTECT Act, you know, they weren't saying solitary confinement wasn't an option for discipline or for people who were at a serious risk of harming themselves or others. It was saying you can use it in these limited circumstances, but it becomes a point where you're no longer using it to ensure the safety and security of the institution. You're using it as you know, pure punishment. It goes beyond sort of being effective to almost revenge. And then it becomes really ineffective of achieving the goal.
I think it's also important to think about it from a systems standpoint where, you know, we keep finding ourselves in a position where we're leaving it up to individuals to figure out a larger systemic issue, which is, again, in addressing societal ills, societal problems, we skew towards punishment and no longer treating people, as Steve Hernandez has been saying this whole time, is how do we get back to this idea of basic humanity? How do we address root causes? How do we address what's happening, not just within this individual interaction, but what led up to the interaction, as Attorney Pierre said, sorry if I'm fumbling your name. We fail to take a look at the larger picture of what's happening and focus too much on what's happening right in front of us at the tip of our nose. And if we work harder to just really see that people are people, and even under stressful situations, everybody on this call has had a moment where they acted out and did something that they regretted, but our consequence wasn't being locked in a box or chained to a bed or anything like that as our punishment. And so what happens when we put people in pressure cooker situations, and how are we addressing the idea that we should no longer be putting humans in pressure cooker situations so that those outcomes happen?
And you know, thank you so much for that. You know, the people prism and the people lens is so critically important in every part of this conversation, because it addresses how we view the issue, right? If the issue is an underlying sociopathy or psychopathy that a person may be experiencing while incarcerated, right? We all know that as human beings, we can be triggered by the very systems and conditions that are around us. So actually, a moment of confinement in a particular institution that is broken may actually cause the person to fall more deeply into a sociopathy or a psychopathy. And you can't address an issue that is a mental health issue, that is a sociological or psychopathological issue, through force and coercion. You need a studied approach that is based on reason and science and ultimately empathy.
Thank you to all the panelists. And now I'd like to shift our attention. We have discussed the justice system, but let us now talk about the juvenile justice system. So this question is for Attorney Capozzi. How are individuals in the juvenile justice system impacted by solitary confinement, and what is being done to help them, or is there any steps that are being acted on right now to reform the process?
Unfortunately, I don't think I could comment on solitary confinement for juveniles if they're not in a juvenile facility, like if they were transferred. But I know in juvenile detention, they really don't have solitary confinement. What they may do is if there is some kind of an issue, a behavior issue, they'll give them a one-to-one where there's a staff member with the juvenile by himself, but there's always someone there with them, which may not be a bad idea to handle if in the adult system, where if there's a therapist or some kind of a social worker talking with the prisoners to what the problem was, why did you do that, maybe what can you do to keep this from happening again. Same thing we would do in juvenile court may work with adults. I know we've had some difficult times in detention this last year. You mentioned before about their rights and their well-being. It was very difficult for family and attorneys to personally visit the juveniles in there, so there was some frustration there. And but I think that they do not believe in solitary confinement for juveniles, at least in juvenile detention. They would always prefer to give them the direct support as best they can. And if there's a need for some kind of a restraint because of a behavior issue, it's usually very quick, it's over fast, and they try to talk them down. They're trained very well how to de-escalate a situation. And a lot of times we'll read the reports about an issue, and they kind of have the two kids who had the issue with each other work it out, or if it's with staff, they work it out. They say they owned it, they apologized. And the one thing that does do is if they're in, we have to review the cases every week. This is all pretrial detention. So if their level is not a level 1, meaning the best, they may not be able to get out of detention if that's going to be the plan for them to eventually go home. So knowing that, a lot of times they will realize that, yeah, they need to behave and follow whatever the rules are and follow through with whatever appointments that were going to be set up for on the outside so that they can get on with their lives back home with their family. It was a difficult time during COVID because even sometimes if the court was on the fence about sending a juvenile home or not because of past behavior issues in the home, we would give them furloughs for just maybe a few hours just to see how they would do in the home with the parent. And we couldn't do that because detention wouldn't let them back in due to COVID. So it's starting to loosen up now a little bit, but I think we're going to be right on track to be better. Sorry it took so long.
You are good. I'd like to open this question up to all the panelists at this moment. If any of the other panelists would like to respond to this question, I encourage you to do so.
I think one thing that can be particularly troubling when you're talking about youth who are incarcerated is that DOC's policies, as I understand, apply system-wide. And so whereas I think of youth as perhaps including those who are still eligible for special education, for example, which can be those who are 18, 19, 21, up until their 22nd birthday. If they're in another facility, if they're in a DOC facility, if they are put on a restrictive housing status, then while the name and the feature may not be exactly the same, the effect of being placed in isolative conditions where the ability to leave a very small cell, where the ability to have meaningful social interaction, where the ability to have educational opportunities, particularly for those who are still eligible for special education, are greatly limited. And it's concerning when you look at system-wide policies that enshrine these restrictive housing statuses as being applicable throughout DOC facilities. and a real concern from at least ERCT's perspective that students with disabilities are not getting access perhaps to the same services, opportunities, and activities within DOC system, perhaps because of their placement on a restrictive status.
I do have some good news about that. In Public Act 21-174, I don't know if you guys are aware, by 2023, they plan on placing all juveniles that are transferred to adult court, if between 15 and 18 years old, they're going to be housed in juvenile facility, either in detention or something new. So they won't be in MYI until after their sentencing or disposition, or unless they're over 18 years old. So that may help some of those issues with the solitary confinement or education, special needs. I'm actually on that committee also. So this was good that I listened to you guys talk about it here, so I could bring that back to my other committee in a couple of weeks.
Thank you so much. So now when we focus on reintegration, Attorney Puryear and Attorney Capozzi, what resources do you think are most needed but lacking in Connecticut to assist individuals, whether they be adult or juvenile, reintegrate after being incarcerated?
So in terms of the adult aspect, I think the thing is most individuals who are incarcerated, some of them have a parole sentence after their incarceration. And if they don't have housing, the parole department will find housing for them. In terms of, but for other people who don't have a parole sentence, sometimes they're released, they don't have housing, they don't have transportation money, they don't have access to a cell phone, maybe they don't even have an identification. Many people who had any benefits, whether they were disability benefits or SSI, those benefits stop when you're incarcerated. And it takes a long time for someone who has no resources upon their release to reestablish those resources. Maybe they don't have a doctor anymore because they lost their doctor, or their mental health provider discontinued services because they were incarcerated. Sometimes they have a limited supply of medications. There needs to be more services to help people transition from the institution to outside. I think the thing is we're really not preparing people to reintegrate into the community. It's sort of like, well, we're done, send you on your way, and then good luck. And then we're surprised when we find people coming back into the system because we haven't prepared them well to be in the community. And some people have been incarcerated for 10, 15 years, and they've lost touch with many of their family members or their friends. And so it can be very difficult and challenging for people to readjust after being institutionalized for so long.
I tend to agree. Oh, I'm sorry.
No.
I tend to agree with Attorney Puryear. We oftentimes look upon supervision, whether it be probation supervision or supervision on parole, as something that may not only continue with that stigma of sort of being still under the auspices of Department of Correction, but in some cases, those people or probation officers, parole officers provide that that sort of support or access to support that persons who have been incarcerated may require. Again, you're looking at people who, may have been incarcerated for, years or months, or, when they left their communities, those might have been the communities that sort of led them to engage in the behaviors that resulted in their incarceration. So, to take someone who may have experienced a substance abuse problem or a mental health problem or experienced homelessness, and now if they're out without probation or parole supervision, they don't necessarily have access to the services. They've been incarcerated too long, where their driver's license has expired, or they don't have the identification to walk into Department of Social Services and get the medical services that they need, or they're dealing with long waiting lists. And I serve on Board of Health Incorporated, and we're finding that a lot of people who had problems with addiction, be it addiction to opioids and so on, having been away for a while and maybe not having drugs in their system, when they come out and possibly use again, their systems are so shocked, where it results in overdose. And those are resources that we probably need to figure out how to provide to those persons who are being released without some sort of supervision.
So people who are living with a criminal record are basically sentenced to a lifetime of discrimination, right? Like, let's be real. And a large percentage of people who are released from DOC are released into homelessness. And if you think about how our systems function outside of the Department of Corrections, what do you need in order to apply for a new license? What do you need in order to apply for a job? What do you need in order to apply for other basic benefits? An address, right? And people often, like I said, are released into homelessness and don't have an address in order to restart the process of rebuilding their lives, right? On top of that, I'd like us to, again, push a little bit further and not think about only the individual actions of the person being released from an oppressive system of incarceration, but think about the systems that are supposed to function around them. Healthcare should be a basic human right. Housing should be a basic human right. Access to healthy food should be a basic human right. And instead, we find our systems continuing to invest in policing and continuing to invest in DOC. So when, as Steve said earlier, this pipeline of people that go into incarceration, 95% of those people go home, and we're not doing anything to address the discrimination and the barriers. And in Connecticut, there are over 550 collateral consequences that people face with living with a criminal record. And that's not just through housing, that's through employment, access to higher education. If you find a person that's able to pull themselves up by the bootstraps miraculously, that wants to start their own job and has to get a license in order to do that, they can't do it because they have a criminal record. And so the question that I think we should continue to ask ourselves is, what purpose does the system of mass incarceration actually serve, besides for stripping people of their humanity and making sure that they don't have an opportunity to thrive after they come out of Connecticut's prisons and jails? So
Thank you for that.
It's not only about addressing the needs of the individual. We also need to be pushing the other systems to recognize that people are people, regardless of what happened on the worst day of their lives.
Thank you, Claudine. And for those who may be watching who are wondering, why should these people have something that even I don't have? A basic right to housing, a basic right to food, a basic right to assistance, a basic right to be productive and to contribute to society. The real question is, why don't you have it as well?
Thank you for your insights. Attorney Capozzi, we've discussed the reintegration and the resources necessary for everyone, but what are there anything in specific to youths or individuals who are coming out of the juvenile system?
Well, we use detention as pre-adjudicatory. So when they are released from detention, they're either going to go to a residential placement, home, or there is a section of detention where they call it secure placement, which could last. The probation period that goes along with that is the maximum is 18 months. They can know for no matter what the crime is. The plan is always in place that to get them to the least restrictive environment as quickly as possible, as long as they follow the plan and the programs that are in whatever facility they're in. And then once they're still on probation, they're released back home. 9 times out of 10, they're going back to their parents or extended family member who had been raising them, or their guardian all this time already. And with that, there are many planning and placement meetings about what to do with them, what kind of programs would be in the community, back in school. As you would expect, because they're kids, they're pretty much well taken care of. The one issue I see doesn't happen often is when our juveniles, they transition from juveniles to becoming 18 and they're still on probation, there's always the danger that the parent could say, I'm done with you, you're out. And there really isn't much that we can do with them unless we can find another family member. There may be some organizations that can help, but the Department of Children and Families usually don't take in 18-year-olds because they're adults unless they're already involved with the department prior to their 18th birthday. I would think that maybe there should be something in place either through the adult system or from adult service providers that could provide some kind of help, especially when it's really not his fault that the parent decided to say, you're out of here. You could be behaving, but I'm done. I want to move on with my life too. It doesn't happen, again, very often, but it's something that we should be realistic about because our kids are now coming here. Some of them come here when they're arrested at 20 years old for something they did when they were 14, and it's serious enough but not transferable. We have to deal with it, and they may be on probation, and we may have to sort of have access to programs and services meant for adults. I mean, I don't think a 20-year-old would want to be in a therapy group with a bunch of 14 and 15 years old. They just don't have the same mental needs and the same life experiences. So that would be something we would like. But like I said, we kind of, we're working on them from the minute they come to court. They're assigned a probation officer. That probation officer tries to get to know the family and the youth, whether they're in detention or out of detention, and working on getting that, whatever the problem is that brought them here, getting it solved so that they don't come back anymore.
Thank you, Attorney Capozzi. So the incarceration process impacts individuals while they're in the system and once they're out of the system. But, once they're out of the system, a lot of adults are going back to families. Mr. Hernandez, this question is for you. How does incarceration impact family dynamic while an individual or a family member is in the system or once they come out? And what policy changes or resources should be enacted to help with reintegration into the household as well?
Well, thank you for that question. All of our best work across the country, and in fact around the world, really recognizes that multi-generational impact is critical to both success, but is also critical to understanding in terms of where we need to address deficit. And family is at the core of that. However it is that you define family, a supportive infrastructure is at the core of that. And so you cannot treat the incarcerated individual or consider the incarcerated individual in a vacuum. You have to think of the children that are impacted outside of that vacuum, about parents, about community. You have to think about the ecosystem around the individual, because it is that ecosystem that will prepare both success, not only for the person who's reentering the societal infrastructure, but also for the support systems that are around that person. We have to think multi-generationally, and we have to think outside of the vacuum of the individual. That's the only way we're going to find success. And by the way, it's the same formula that each of us in this panel benefit from as well.
Thank you, Mr. Hernandez. Now I'd like to open this question up to all of our panelists. If you would like to speak on this question, we encourage you to do so. Okay, with that, we can move on to the next question. I'll be handing it over to Miles.
Thank you so much. So, Attorney Capozzi, some legislators have been recently pushing for stricter measures for juvenile defendants. And what do you think about the current state of juvenile justice in Connecticut?
You know, when I read this question on the email, I had a lot of thoughts. I mean, the one thing I've been in juvenile prosecutor and been in a probation officer before that for the last 25 years. I've seen things go up. I think I've seen things go from incredibly violent in the mid to late 90s to now we're sort of back in that area where it's not as simple as, oh, it's gang violence, fighting for a corner like it used to be. This is sometimes as simple as he disrespected me on social media, so I'm going to go shoot him. And this last year and a half or so during the pandemic, when we had basically juveniles had free reign, they were just out there. Even if they were arrested, they were not even seen in court for months. So many times they'd be back out doing the same thing. I mean, I had one, he was arrested 30 times in the 4 months before we opened back court again for stealing cars or breaking into cars or being in a stolen car. And unfortunately, it just, some juveniles and some kids, it showed their character that, you know, when the system is not in place perfectly like it usually would be, they don't keep up their end of the bargain by behaving themselves and making it better for everyone else. On the other hand, they also didn't have, if they did need services, there was no services available. There was nothing available for anyone. Even when we had court open again, we had difficulty finding even service providers for some things as intricate as a sex assault defendants, victims, or just in general, there's the general services for the kids that we already had on probation. So is it all their fault? No. Should the parents have been a little more responsible? Yes, but I understand it was a difficult time. And we're still feeling the impact of that, where kids felt, you know, just like if you have kids at home, if you leave them alone and they're going to do wrong things without somebody stopping them or disciplining them, they're going to probably do it again until they're told to stop doing that. I know that in the past we had the transfer laws were a little bit looser. Now they're very strict as far as what can go to adult court. Only all A felonies, certain B felonies, everything else has to have a hearing as to determine whether it's in their best interest to go to adult court. I don't agree with that. I think that a lot of times we were professionals. We knew what to do and what should be done. And yes, they may have a right to say that it shouldn't go to adult court. But I think that it's when you make it so strict that there's no way to do it, it makes it more difficult to process these cases correctly. Also, during COVID, detention wasn't taking anything in unless it was either super incredibly violent, something that was going to be transferred to adult court like murder or armed robbery or sex assault, first degree. And at that point, police were being told, okay, you have this kid, you arrested him 10 times. Well, you're going to have to let him go again. So I understand the reasoning behind it. There should have been, they were trying to keep the population, the detention low so that there wouldn't be the risk of further infection from COVID. I understand that. But at some point there has to be something in place that to keep some control. Juveniles, they are children, meaning they're not fully developed. They don't understand that what they're doing is wrong. And if they're not told that it's wrong on a regular basis, they will continue to do that. So, I mean, now again, it seems a little bit better. We're, detentions, I'm not saying it's good to put someone in detention all the time, but it should be available should the need arise. And sometimes the need arises more often than not. If they're considered a risk to public safety. I wish the transfer laws weren't so strict. I wish it was a little easier to send someone that's an incredibly violent offender to adult court. And once they're there, the adult court should have a lot of options too. Although they have youthful offender laws, maybe those laws should be expanded to include, some of the same things that make juvenile court great is the confidentiality, which I guess is not as confidential as it used to be. They do have abilities to get their record erased in juvenile court. Maybe that if they're in adult court, should be something that could be available in place for them there also. I'm not saying it should be for everybody, but maybe it's something that's an incentive to do well, whether it be in adult court or juvenile court. I think what we're going through right now is bad. I think kids are, again, they're not afraid. They're not afraid of the police. They're not afraid of their parents. They're not afraid of doing wrong, and they don't understand that there's got to be a certain amount of respect for other people's property and their rights. They're just not learning that. I think we're going to have to. I'm no expert. I'm not a doctor on these kind of matters of mental health, but something needs to be done to get them back in line. I think parents need help. The police need training on how to deal with these kids in a way that maybe try to keep them from coming back out over and over and over again. I wish I had the answer. I try to do what I can here when they come in. I try to be open-minded as to their reasons. I'll listen to them and say, at least tell me you're sorry. At least say something that makes me think that you're not going to do this again. And we're working on all that. And I think that should be something we should be working on. Everybody should be working on. Again, sorry it takes so long, but this is a very difficult issue, and it's hard for me to say things are going okay when I see what's going on in the state where kids are, unfortunately killing people, and whether by purpose or not, it shouldn't be happening. But I have a lot of confidence that we can fix the problem.
Thank you so much. And so we'd like to open that question up to the panelists. Just to repeat it. Some legislators have recently been pushing for stricter measures for juvenile dependents. What do you think about the current state of juvenile justice?
I guess I would just start out with this idea of we're talking about kids. We're talking about people's children. We're talking about kids who are growing up in communities that are clearly undervalued by people that are supposed to be in leadership. We're talking about kids who are growing up in situations where society continues to tell them that they're not valuable, and that the only solution to when they mess up or make a mistake is to lock them in a box. Think about what that does for how a person views themselves, what that does for how quote unquote reckless a kid can become, because they're like, well, F it, society doesn't care about me anyways, so I'm just going to go out and do this thing. This notion that they're not afraid of the police, they're not afraid of the consequences, I actually think is false. I actually do believe youth are afraid of the police. I do believe they're afraid of losing their lives. But when you have a society that continuously tells them over and over and over again that you don't matter, you're not valuable, you start to just throw caution to the wind. And so I again push us to think about the systems that put people in this position in the first place. What happens if we start investing in schools? What happens if we start investing in programs for kids to do that aren't just that like value other pieces of their identities, like the arts or sports or cooking or something like that, right? What happens if we start to invest in quality housing? What happens if we start to invest in all of these other pieces that make up a person's life? What happens when we divest from the systems that are only focused on what happens after the bad thing happens? I guess is what I want us to continue to think about. Is the state of juvenile justice, if we look at statistics, crime is actually down in Connecticut. If you look at statistics, kids, people should just lock their freaking cars. I don't know how else to say that. Just lock your cars. Don't leave your fobs in your cars, and maybe it won't get stolen. I don't know.
You're right about that.
Right. So like, this isn't a knock on prosecutors. This isn't a knock on police, because everybody is just doing their jobs and the roles that they have taken up in society. But we need to start to think about solutions that are addressing the back end of the system. What happens before a kid ends up entangled with police? What happens before a kid ends up in front of a judge? What are we doing to address those things to prevent that stuff from happening?
I could respond to that, because I know that before they come to court, most towns have these juvenile review boards where they're referred to for mostly minor offenses, but it has a lot to do with making the community whole again after whatever they did was wrong. There's some mediation involved. I found that very helpful. And even if it does work out, the case is never even brought to court. You don't even know what happened. If it doesn't work out, it does come to court, we still have options with them as far as mediation. There were non-judicial cases, meaning that they meet with a probation officer who try to get them to take responsibility for their action, and again, put things in place so they don't do it again. And again, at some point, the record is erased, so there's not the stigma attached to it like in adult court. Usually, by the time it gets to me, they've already been through here a few times and have not succeeded in the community. And then even still, I'm trying to sort of I always say, why are you here? What's the reasoning behind it? We have good staff here and good probation people that try to get to the bottom of that as best we can. Very rare I get families that have no attorney where I can actually talk to the accused juvenile and his parents. And when I do, it's usually, I get a good idea of what's going on in the home. And a lot of times I'll say, you shouldn't even be here. I said, you got a good mom who took time off from work to bring you here just because you got involved in being in a stolen car or you did something foolish. We don't want you, this is not the end of the world, but I usually make them, not usually, but a lot of times I'll make them do apology to your mother. And I try to be creative around whatever the situation is to keep it from happening. But again, at some point, if they keep coming back and back and back, and I don't know how many times I could be lenient, at some point there's going to have to be a need for probation. And as far as putting them in a box or in detention, something like that, it's usually only as a last resort. And it's only because everything else has been tried. They've shown that they're a risk to public safety, or if they don't show up to court and refuse to show up to court, we get them here just to sort of say to them, look, if you don't come to court, there's going to be a consequence. And we're trying to teach them with that for every action that you do that's bad to the community or negative, there's going to be a consequence. And that's, hopefully they learn from that. If they can't learn from that for whatever reason, then we try to help them get past that also, as far as getting them the help with their mental health needs, education. The probation's in contact with the schools on a regular basis, making sure that it's an appropriate setting for them. We work hard to try to keep them out of the adult court, but unfortunately, when things are happening now and they're carrying guns, which is something I really have a problem with. I mean, and you could say it's a bad day, but I just don't. Once you start carrying a gun, if you become dangerous to yourself and to other people, and if an innocent person has to be hurt or killed for something foolish you did, I don't know what I could do here. I mean, we try the best we can, and if we can help them, we will. But at some point, and not that I think we're throwing them away, but I think the public may demand that something more drastic has to be done to them.
Thank you, Attorney Capozzi. Are there any other panelists who'd like to speak on this question?
Just briefly, I just want to state that regarding the transfer to adult court, in 2007, the Centers for Disease Control and Prevention published the findings that found that transfer to the adult criminal justice system typically increases rather than decreases rates of violence among transferred youth. So I think it's important to remember, is this an effective tool for obtaining the goal of public safety? And can we use other sort of tools? Can we do what Claudine Fox says, which is, and Steve Hernandez has been saying repeatedly, which is addressing the systems that brought us to this place. I think that a lot of states are recognizing that juveniles are not adults. People who are 18, 19, 20 don't have the brain that a 40-year-old does, that they have significant maturity that has to be developed, that they're missing some development in the prefrontal cortex, which impacts their ability to fully appreciate the consequences of their actions, makes them high risk takers, and impacts their ability to plan. So many states are actually increasing the age of majority from 18 to 19 to even 21, and not prosecuting juveniles in adult courts. And that's really the direction that we should be taking.
I just want to add, as an attorney, I almost every day feel the weight on our institutions of law to address the ills that other parts of the system have perpetuated. And part of those ills include a lack of impatience when it comes to poverty, a lack of impatience when it comes to early traumas, when it comes to early childhood adverse experiences. Because we are not impatient where the harm is happening, all we are seeing is the impatience in addressing the outcomes. And that is falling squarely on the institutions of criminal justice, which isn't fair to the institutions, and it isn't fair to our society, and it certainly isn't fair to the people that are under its thumb. So unless we really organize around an impatience around root causes, we're going to continue to face these issues moving forward.
As we can see from the discussion taking place here, this is clearly a multifaceted issue, and clearly reforms need to be made here to help the youth of our society. But now I'd like to transition and open this question up for all the panelists. And the question is, for all those who are interested in further reforms, what do we do? What are the next practical steps in addressing those issues? And what are some ways you suggest that the public can get involved in correctional reform?
I'll start, because this is my everyday job, basically. I think first and foremost, Representative Porter puts it best, right? The people closest to the problem need to be closest to the solution. And so a lot of the progressive and fantastic reforms that we've seen in our system, in our criminal legal system, actually come directly from advocates and organizers and people who are directly impacted by the oppressive system of the criminal legal system, right? And so, this legislative session, we saw a couple of major wins around clean slate, the automatic erasure of records for people who are living with certain Class D felonies, E felonies, and all misdemeanors. We saw the first passage in the country of making prison phone calls free for families, which allows this idea, which addresses reentry and really ensures that people have a direct line of communication to their families as they're trying to reenter society once their time is up. You know, we have seen a lot of those wins happen, and there's still a lot of work to do, you know, around addressing the discriminatory practices that happen for people living with a criminal record, around employment, housing, and higher education. You know, we again need to continue to figure out how to codify the PROTECT Act to ensure that we take this a step closer to abolishing solitary confinement. You know, there is a lot of work that started last summer around the police accountability bill because of the uprisings that happened after the death of George Floyd. And what are we doing to limit and restrict the powers and reach of over-policing, particularly in Black and Brown communities, to ensure that kids aren't even coming into contact with police in the first place, to divert them from coming into contact with the criminal legal system in the first place, right? There's still a lot of work to do to address those issues that fall under this one word of divest, right? When we divest from these reactionary systems and start to invest in preventative systems, we'll start to see a change in the overall outcomes of lives of people in Connecticut. So there are a lot of different ways that we can address reentry. There's a lot of different ways that we can address abolition. There's a lot of different ways we can address the criminal legal system. But right in front of us, you know, we should start to figure out anti-discrimination protections, and so on and so forth. So I'll stop there.
Thank you, Ms. Fox. Any other panelists?
I so appreciate what Ms. Fox said, and if I can borrow from some of the incredible disabled advocates that I sometimes work with, nothing about us without us. I think that really is, if I could sort of use disabled advocates' common saying to put a finer point on what Ms. Fox shared, I think that's certainly how DRCT feels about these issues.
And for people who may be watching, who care but don't know what to do, you know, if you see something, say something, right? If you see an adult in a conversation referring to a child as an animal, if you see an adult referring to people who live in desperate conditions as subhuman, say something, because it is rooted in that view, that point of view of people who are also residents of the state of Connecticut. Rooted in that view is the problem.
Thank you very much, Mr. Hernandez. This is a very complex issue, and the public and community members want to get involved. Are there any organizations in place currently, ones that you're working with, that you would suggest that individuals check out or get involved in order to participate in the reforms and the reform process?
Us. You know, we take an organizing approach to policy work, and we believe that everybody plays a role in ending mass incarceration, regardless of your title or how you show up in the world. Your voice is valuable, and you are valuable. So join the Smart Justice campaign. Join, you know, find the closest. A lot of like UCC churches in neighborhoods have like advocacy groups that you can, you know, start to inquire about. People are doing little pockets of things all over the place. So find the thing that you're the most passionate about and just latch on and just start showing up. Send an email to the legislator telling them why you're angry about something. You know, our elected officials work for us. And I think that's really important for us to remember as we continue to shape and move towards liberation, is that you can participate and say what you need to say. And once you do it the first time, it becomes easier every single time after that.
And if you're a member of some of our institutions here, if you are a member of the bar, if you're a leader in community, push back, because oftentimes it's our silence, even in the things that we are required to do, that perpetuates.
All right, thank you so much to all the panelists for your insightful answers. We'd like to thank everyone for taking the time out of your busy day to join us this afternoon and discuss this critical concept. And we wish everyone, or a critical issue, we wish everyone a wonderful rest of their afternoon. Once again, thank you so much to the panelists for coming. Thank you so much to the viewers for watching. Yes, thank you.
Thanks for having us.
Good evening, everyone.